President Roosevelt ignored the calls for Justice Black's resignation, and Black stood his ground. He wasn't going anywhere. But the question remained: would Justice Hugo Black be willing to protect the rights of all? There would be no quick answer, because in the 1940s, outside of economic liberties, the court had almost no history on protection of individual rights. It started with children who were kicked out of school, because in the run-up to war, the schools were at work building patriotism. In Minersville, Pennsylvania, all kids had to salute the flag.
There were two little kids there, Lillian Gobitis and William Gobitis. Lillian was 12, William was 10. They were Jehovah's Witnesses, and it was against their religious faith to pay homage in any way to the flag. The Minersville School District said no exceptions, and these children were expelled.
So their parents brought suit on the basis of their religious freedom, and they won at the lower courts. And then it came up to the Supreme Court of the United States.
It was a brand new Supreme Court, remade by 5 fresh Roosevelt appointees. Black was the first, but the ornament and leading light was to be Felix Frankfurter. He might have been the most famous lawyer in the country, a towering figure in Roosevelt's brain trust. He was an immigrant, an Austrian boy who landed on Ellis Island at age 12, without a word of English, but he dazzled everybody who saw him since, from the Lower East Side to Harvard Law School and beyond.
Everybody assumed that Frankfurter would become the leader of the liberal wing of the court. He was a founding member of the American Civil Liberties Union. He was an early supporter of the NAACP. He defended Sacco and Vanzetti, the 2 immigrant anarchists. He advised Wilson. He advised Franklin Roosevelt when he was governor of New York. And of course, he became almost a one-man employment agency for the New Deal. They were called Frankfurter's hot dogs.
Some jurists come to this court hat in hand. Frankfurter swaggered in. He expected to sweep the court along, and he did. He wrote the flag salute opinion for an 8-to-1 majority.